Good afternoon. This is Judge Duckworth. Who do I have on the line?
Good morning, Judge. My name is Muriel. ID 396188. I'll be your field interpreter today.
All right, very good. Good afternoon, sir. State your name, please.
Bonsoir, capable de nom, s'il vous plaît.
Madam Interpreter, I think you just need to speak a little bit louder or speak more to the microphone.
Okay. Sorry. Est-ce que, s'il vous plaît, capable de nom?
Oui. Gosman
Okay,
Cassis.
Comment il est?
Gosman Cassis.
Jasmine Cassis.
Gosman Cassis.
All right. Mr. Cassius, you're here for initial appearance.
Là, je dis pour vous présenter devant.
You've been arrested on the charges of attempted burglary of a dwelling.
Yo arrêté ou dans charge pour ou t'a essayé voler un bagay.
Possession of burglary tools and criminal mischief.
May you please repeat the last sentence for me? My honor, I didn't hear it.
Okay. Possession of burglary tools and criminal mischief.
Possession de bagay que ou volé et puis yo jè bagay nan men.
I'm going to appoint the public defender to represent you.
Mwen pral ba ou yon avocat qui pou représenter ou.
The bonds have been set at $1,000 on count one.
Et comme pour bay la c'est $1,000 nan premier compte là.
And $500 each on counts 2 and 3.
$500 pour compte 2 et compte 3.
In addition, I'm going to order that you not return to the scene of the offense.
Et puis tout m'a demandé pour pas retourner dans côté bagay la te fait là.
Good luck, sir.
Bonne journée.
Thank you, Madam Interpreter.
Thank you for using our services, my honor. Have a wonderful day.
All right, could I have counsel identify themselves for the record?
Brenda Eugene, on behalf of the State Attorney's Office.
Letitia George, on behalf of the Office of the Public Defender.
Thank you. Do you want to do we'll just do the end. 33-day, we'll do at the very end.
Yeah, that's fine.
Go ahead. You can go.
All right. Good afternoon, sir. Your name, please?
Austin Bradshaw.
Mr. Bradshaw, you're here for initial appearance. You've been arrested on a city ordinance case, violation, disorderly conduct.
And Your Honor, the offer from the state to resolve the case is an adjudication of guilt, credit time, and court costs, and Mr. Bradshaw would like to accept it as a plea. The case number.
It's 23 MO 328 AO. Thank you. All right, Mr. Bradshaw, I've been handed a plea form indicating you wish to plead no contest to the charge. You'd be adjudicated guilty. You'd be given credit for the 2 days you served in jail, and I'll give you time to get the cost paid, and that would resolve this matter. You'd be processed and released on this case today. Is that your understanding, and is that what you want to do?
Yeah.
Okay. Holding up the plea form has your name at the top. Is that your signature at the bottom? All right. How do you plead a disorderly conduct?
No contest.
I'll accept that. I'll adjudicate you guilty, credit for 2 days. I'll give you 350 days to get the cost paid. and you've got 30 days to appeal, so you'll be processed and released on this case today. All right, good luck.
And, your, McCormick Michael, she's discussing a plea.
Yep, that's fine. Good afternoon, sir. Your name, please?
That is Terrell.
Mr. Terrell, you're here for initial appearance. You've been arrested for petty theft with 2 prior convictions. I'm going to appoint the public defender to represent you. You got a $1,000 bond. Going to order you not to return to that Walgreens on North Hiawassee.
All right.
Good luck. Good afternoon. Your name, please?
My name is Elvis Mbuza.
Sir, you're here for initial appearance. You've been arrested for failing to appear at a pretrial conference back in January on a charge of trespass.
Your Honor, the offer from the state is an adjudication of guilt, 30 days in the Orange County Jail, with credit for, I don't know. Madam Clerk, do you have the time?
Would be 2.
And no return to 5426.
Oh, okay.
You're gonna look into it. Esplanade Park Circle, Your Honor. Mr. Mbu would like to accept and enter a plea of no contest.
Okay.
Yes, 41 days.
41 total. Okay.
Credit time, sir.
Okay.
All right. Sir, I've been handed a plea form. Indicating you wish to plead no contest to the charge. You'd be adjudicated guilty, be credit for time served of 41 days, ordered not to return to that address of 5426 Esplanade Park, and that you'd have to pay costs, and I'll give you time to get that paid, but you'd be processed and released on this case today. Is that your understanding? Is that what you want to do?
Yes, Your Honor.
Holding up the plea form has your name at the top. Is that your signature at the bottom? You have to answer out loud.
Yes, Your Honor.
Okay. All right, to that charge of trespass, how do you plead?
I plead no contest.
Okay, I'll accept your plea. I'll adjudicate you guilty. Credit for 41 days. Order no return to the scene. I'll give you 350 days to pay the cost. You've got 30 days to appeal. All right. Good luck, sir.
Thank you, Your Honor.
Good afternoon. Your name, sir?
Jaime Ferrar.
Mr. Ferrar, you're here for initial appearance. You've been arrested for petty theft.
Yeah, I gotta do 160. Give me a 988.
And, Your Honor, as to the case number 2022 MM820180, he is incompetent to proceed.
Okay.
Your Honor, I gotta do 160. Give me a 988.
Okay. All right, I'm going to appoint the public defender's office, stay the bond at $250. Take no action on the out on bond. Don't go back to that Walmart, okay?
Yeah, but you did that 405. They owe me about 619.
All right.
If I get the T12 paper, you pass it to me or what?
All right, good luck. Good afternoon, sir. Your name, please?
Michael Bruce McCormick.
Oh, okay. All right.
I'm sorry, you did say that.
All right, Mr.
You're
McCor-
ready for Mr.
All right, Mr. McCormick, you're here for initial appearance. You were arrested for open container and littering as a city ordinance violation.
State is an adjudication of guilt, credit, time served, and court costs. Mr. McCormick would like to accept and enter plea of no contest.
That's 23MO331AO. All right, sir, I'm handed a plea form indicating you wish to plead no contest to the charge. You'll be adjudicated guilty, be given credit for the 2 days you served in jail, and I'll give you time to get the cost paid, and that'll resolve this case, and you'd be released on this today. Is that your understanding, and is that what you want to do?
Yes, sir.
All right, I'm holding up the plea form. It's got your name at the top. Is that your signature at the bottom? Is that your?
Yes, sir. Yes, sir.
All right. To that charge of open container, how do you plead?
No contest.
And littering, how do you plead?
No contest.
I'll accept those pleas. I'll adjudicate you guilty on both, give you credit for 2 days. I'll give you 350 days to get the cost paid. You've got 30 days to appeal. So you'll be processed and released on this case today.
Yes, sir.
right,
Thank
good luck.
you.
Morning, sir. Your name, please, or good afternoon?
David John Hall.
Mr. Hall, you're here for initial appearance. You've been arrested on a city ordinance violation of,
In the offer from the state, Your Honor, is an adjudication of guilt, credit time served, no return to 633 Lake Dot Circle, as well as court costs. Mr. Hall would like to accept, and Mr. Tulsa Ram.
okay. It's 23MO 329AO. All right, Mr. Hall, I'm handed a plea form indicating you wish to plead no contest to the city ordinance violation. It's trespass. You'd be adjudicated guilty, be given credit for 2 days that you served in jail, pay the cost, and be ordered not to return to that address. That would resolve your case, and you'd be processed and released on this case today. Is that your understanding, and is that what you want to do?
Yeah.
Okay. Holding up the plea form, it has your name at the top. Is that your signature at the bottom, sir?
Yes, sir.
Okay. All right, to that city ordinance violation trespass, how do you plead?
No contest.
I'll accept that. I'll adjudicate you guilty, credit for 2 days, order no return to 633 Lake Dot Circle. That's the William Booth Towers. If you go back and they see you, you're just going to get rearrested, so don't return. And I'll give you 350 days to pay the cost. You've got 30 days to appeal. You'll be processed and released on this today. All right, good luck, sir. Good afternoon, sir. Your name, please?
Mr. Ortiz, Yondell.
Mr. Ortiz, you're here for initial appearance. This is it's an add-on. Looks like you got a lot of stuff going on.
Yes, Your Honor.
This is a city ordinance violation where you failed to appear for arraignment. Maybe you may have been in jail. It's just the other day for a charge of disorderly conduct.
Yes, Your Honor. I just ask that you stay the bond.
Okay. All right, so I'll stay the bond at $2,000, and I'll appoint the public defender. Good luck, sir.
Good afternoon, Your Honor.
Good afternoon, counsel.
Judge, thank you for calling this case out of turn. This is Mr. Ivan Rivera, Assad Ali on Mr. Rivera's behalf.
Okay. All right, and Mr. Rivera, you're here for initial appearance. Like you've been arrested for aggravated fleeing or eluding with injury or damage. And you're out on bond on a couple of cases. Okay, what's the state's position on a bond and the out on bond cases?
Your Honor, with regard to the aggravated fleeing and eluding, he is entitled to a bond. I would have you note, however, that with regard to 22 CF 13766, that is an aggravated assault, 3 counts, and formal charges have been filed. Arraignment is set for March 28th. He also has another fleeing and attempting to elude. That occurred on February 13th. Formal charges have not been filed yet, but I would like the court to take into consideration that there is another fleeing and attempting to elude out there, and he has other driving offenses, convictions, Your Honor.
All right, counsel?
Yes, Your Honor. If I may respond, I have a brief probable cause challenge as to the instant aggravated fleeing to elude that is before the court today. As far as reading this affidavit, Your Honor, I don't believe that there's sufficient probable cause. As far as Mr. Rivera being the driver of the vehicle, that's entirely circumstantial, and obviously circumstantial evidence can be sufficient for probable cause, but I would have Your Honor note that there was a other individual within the vehicle. Mr. Rivera was never actually seen driving the vehicle. I believe when he was finally located by law enforcement, he was outside of the vehicle. And he also did indicate to officers multiple times that he was a passenger within the vehicle and the other individual who fled was the actual driver. So it would be our position that this is insufficient for probable cause as to the instant charge that is before the court. And whenever Your Honors finish reviewing the affidavit, we do have some bond factors I would ask the court to consider.
Okay. As to the probable cause state,
Your Honor, I saw something about the passenger being a skinny black male, and that the officer, when he tried to make contact with the driver, he was a heavier male in a hoodie. Defendant is before you, and so you can see whether or not that description fits, Your Honor. But it does appear that the officer was able to see the driver.
all right, I'm going to deny the probable cause challenge. I think there's sufficient evidence in the affidavit to at least justify probable cause that Mr. Rivera was driving. Okay.
Understood, Your Honor. If I may present some bond factors, Mr. Rivera has been living between Orange and Osceola County for the past 7 years. He has several family members within both of those counties. He is gainfully employed, Your Honor. He does some drywall work, and I would have the court note that he is a sole provider for his 2 children. He has a 1-year-old and a 3-year-old son. He's not a flight risk, Your Honor. Once this case happened, obviously, he immediately retained our office. We also represent him on his other pending cases, Judge. He's indicated to me that he is amenable to complying with whatever pretrial services and restrictions that the court or state would ask for as far as setting a release of monetary bond on this case. And Judge, I don't know if the court allows or if there's pretrial services with GPS monitoring. I'm not sure if Orange County currently has that, but Mr. Rivera would just like the court to know that he is amenable to electronic monitoring if available.
All right, on the new aggravated fleeing or attempting to elude, I'm going to set the bond. I'm going to set that bond at $2,500. It appears that at the initial appearance when he was arrested for the other fleeing or attempting to elude last month, the court chose not to take any action on the bond that he was out on, and instead gave a probably a higher than average bond on that fleeing or attempting to elude. So, but that case has not been filed on, so I'm not going to take action on that, but I am going to revoke the bond in 22 CF 13766 AO, the aggravated assault that's been filed on. I'm going to set that bond at none. So, Mr. Rivera, your attorney can file the appropriate motion in Division 22 and ask that judge for a bond, ask for a bond back, but at this point, it's going to be no bond.
Thank you, Your Honor. That's my only matter. May I be excused?
Yes, sir. Thank you.
Judge.
Good day.
Cynthia Burgos, mental health, Your Honor.
Thank you.
Can we reset for tomorrow? There's an offer to resolve the case, Your Honor.
Yes, Cynthia Burgos will reset tomorrow. Possible plea. Good afternoon, sir. Your name, please?
Known as Duronville.
Mr. Duronville, you're here for initial appearance. You've been arrested for trespass after warning.
We'd ask that you set a bond, Your Honor.
I'm going to appoint the public defender, and I'll stay the bond at $500 with the order not to return to the Lynx Bus Station, 455 North Garland. All right, good luck, sir. Good afternoon, sir. Your name, please?
Scott Hart.
Mr. Hart, you're here for initial appearance. You've been arrested for petty theft. Going to appoint the Office of the Public Defender to represent you.
And, Your Honor, the offer to resolve Mr. Hart's case is in a withhold of adjudication, credit time served, no return to 3525 Gardens Ridge Way, in court costs, and Mr. Hart would like to accept the state's offer and enter a plea of no contest.
Okay. All right, Mr. Hart, I'm handed a plea form indicating you wish to plead no contest to the offense of petty theft, understanding to be a withhold of adjudication, credit for 2 days that you served, not to return to the Hobby Lobby, and you've got costs, and I'll give you time to get those costs paid. That would resolve this matter. You'd be processed and released on this case today. Is that your understanding? Is that what you want to do?
Yes.
Okay. Holding up the plea form, it has your name at the top. Is that your signature at the bottom?
Yes.
Okay. To that charge of petty theft, how do you plead?
No contest.
I'll accept that. I'll withhold adjudication, credit for 2 days, no return to the Hobby Lobby, 3525 Gardens Ridge Way. I'll give you 350 days to pay the cost and 30 days to appeal. All right. Good luck, sir. Good afternoon, ma'am. Your name, please?
Kristen Bragg.
Ms. Bragg, you're here for initial appearance. You've been arrested for failing to appear for your arraignment back on February the 15th on a charge of petty theft of $100 or more, and the judge set the bond at $2,000. I'll appoint the public defender to represent you. Good luck.
Oh, it was out of order. I'm sorry. I'm sorry, Your Honor. The offer from the state was an adjudication, credit time served, no return to 16130.
Is she on probation?
My probation in Lake County, they reinstated it because this charge happened way before I got put on probation, Your Honor.
Okay, all right.
Okay, so I
We
won't.
double checked.
Okay. I'm good.
No return to 1613 New Independence Parkway, as well as court costs, and Ms. Bragg would like to accept and enter a plea of no contest.
Okay. All right, Ms. Bragg, I'm being handed a plea form indicating you wish to plead no contest to the charge of petty theft of $100 or more. You'd be adjudicated guilty, you'd be given credit for the 2 days that you've served in the county jail, no return to 1613 New Independence Parkway, that's a Walmart, and I'll give you time to get the costs paid. That'll resolve this matter, and you'll be processed and released on this case today. Is that your understanding, and is that what you want to do?
Yes, Your Honor.
Okay. Holding up the plea form, it has your name at the top. Is that your signature at the bottom?
Yes, sir. Yes, Your Honor.
All right, to that charge of petty theft of $100 or more, how do you plead?
No contest.
I'll accept that. I'll adjudicate you guilty, credit for 2 days, no return to that Walmart. Give you 350 days to pay the court costs. You've got 30 days to appeal. You'll be processed and released on this case today.
Thank you.
All right, good luck.
How you doing, Your Honor?
Good afternoon. Your name, sir?
Rick Caesar.
Mr. Caesar, you're here for initial appearance. You were arrested for failing to appear at a pretrial conference back on February the 3rd of this year. The judge set the bond in that case at none. I'll appoint the public defender. Good luck.
No.
Your Honor, Tina Gilbert is behavior.
Your Honor, there is actually an offer to resolve both cases. Can we reset for tomorrow?
We'll reset Tina Gilbert for tomorrow. Well,
Yeah, well, I'm sorry, one case, two charges.
At 2013. Good afternoon, sir. Your name, please?
Solicito III.
Mr. Solicito, you're here for initial appearance. You've been arrested for failing to appear for an arraignment November of 2020 on a charge of trespass.
Yes, Your Honor. And the offer from the state to resolve his case is an adjudication of guilt, credit time served, no return to Universal Studios. There's a cost of investigation in the amount of $26.51 to the Orlando Police Department. We would like to accept the state's offer and enter a plea of no contest.
Okay, thank you. All right, sir, I've been handed a plea form indicating you wish to plead no contest to the charge. You'd be adjudicated guilty, be given credit for the 4 days you served in jail, ordered not to return to Universal Studios to pay the costs, and that includes a cost of investigation of $26.51. That would resolve this case today, and you'd be processed and released on this case today. Is that your understanding? Is that what you want to do?
Yes, sir.
Holding up the plea form, it has your name at the top. Is that your signature at the bottom?
Yes, sir.
All right, to that charge of trespass after warning, how do you plead?
No contest.
I'll accept that. I'll adjudicate you guilty, credit for 4 days, no return to Universal Studios. I'll give you 350 days to pay the court cost and the cost of investigation to Orlando Police Department, the amount of $26.51. You have 30 days to appeal, so you'll be processed and released today, all right?
Thank you, sir.
Good luck.
Thank you.
Good afternoon, sir. Your name, please?
Timothy Dwayne Lyman.
Mr. Lyman, you're here for initial appearance. You were arrested for a city ordinance violation of disorderly conduct.
Can I just get the case number, Your Honor?
It's 23 MO 330 AO.
And the offer from the state is an adjudication of guilt, credit time served, as well as court costs. Mr. Lyman would like to accept and enter a plea of no contest.
All right, Mr. Lyman, I'm handed a plea form indicating you wish to plead no contest to the charge. You'd be adjudicated guilty. Credit for 2 days. I'll give you time to get the cost paid. That'll resolve this matter. Is that your understanding? Is that what you want to do?
Yes, sir.
Holding up the plea form, it's got your name at the top. Is that your signature at the bottom?
Yes, sir.
Okay. To that charge of disorderly conduct, how do you plead?
No contest.
I'll accept that. I'll adjudicate you guilty. Credit for 2 days, 350 days to pay the cost, 30 days to appeal. You'll be processed and released on this case today, all right? Good luck.
Thank you, sir.
Good afternoon, sir. Your name, please?
Tuấn Ngọc Nguyễn.
Mr. Winn, you're here for initial appearance. You were arrested for a city ordinance violation of disorderly conduct.
The offer from the state is an adjudication of guilt, credit time served, as well as court costs. And he would like to accept the state's offer and enter a plea of no contest.
Okay. All right, sir, I've been handed a plea form indicating you wish to plead no contest to the charge. You'll be adjudicated guilty, credit time served. I'll give you time to get the cost paid, and you'll be processed and released on this case today. Is that your understanding, and is that what you want to do?
Yes, sir.
Okay. Holding up the plea form, it has your name at the top. Is that your signature at the bottom?
Yes, sir.
To that charge of disorderly conduct, how do you plead?
No contest.
I'll accept that. I'll adjudicate you guilty, credit for 2 days, 350 days to pay the cost, 30 days to appeal. So you'll be processed, released today. All right, good luck.
Thank you, Honor.
Robert Perry is bonded.
Harry bonded, thank you. Good afternoon, ma'am. Your name, please?
Whitney Turner.
All right, Ms. Turner, you're here for initial appearance. All right. You were arrested for county ordinance violation, loitering,
Yes, Your Honor.
and I'll appoint the public defender to represent you.
And, the offer from the state to resolve the case is an adjudication of guilt, credit time served, and no return to the mapping zone. Your Honor, and Ms. Turner would like to accept and enter a plea of no contest. Could I please have the case number?
Yes, it's 23 CO 287 AO. All right, Ms. Turner, I'm handed a plea form indicating you wish to plead no contest to the charge. You'd be adjudicated guilty, be given credit for 2 days that you served in jail, and that you're not to return to the mapping zone, and I'll give you time to get the cost paid, and that would resolve this case today, and you'd be released on this case today.
Yes,
I take no action. You've got a driving license suspended. That you've got, looks like you've got court coming up later this month.
Yes, I'm getting that resolved
Okay.
as we speak.
Okay. All right, so holding up the plea form. It's got your name at the top. Is that your signature at the bottom?
Yes, Your Honor.
All right, to that charge of loitering, how do you plead?
Not guilty. No contest.
No contest, okay. I'll accept your no contest plea. I'll adjudicate you guilty, credit for 2 days. Order you not to return to the mapping zone. Understand that the officers that patrol the mapping zone, they'll recognize you if you go back.
Yes, Your
And
Honor.
then you'll just be right back here, so you don't want that, all right? So, no return to the mapping zone. I'll give you 350 days to pay the cost, 30 days to appeal. So you'll be processed and released. I'll take no action on the out on bond.
Thank you, Your Honor.
All right, good luck.
Woods, bonded.
Woods bonded, thank you. All right, good afternoon. Your name, sir?
Jinski, Jervelis.
Thank you, sir. You're here for initial appearance. You were arrested for failing to appear at an arraignment on a charge of driving with a suspended license. The judge set the bond at $2,000.
And Your Honor, you did appoint us, correct?
I'll appoint the public defender to represent you.
Alex Hurtado, bonded, Your Honor.
Thank you.
Sylvester Lopez Frisley, bonded also, Your Honor.
Okay. All right, good afternoon, sir. Your name, please?
Michael Robbins.
All right, let's see here. All right, so this appears to be an add-on, 23 1294, okay. So it appears that you were previously arrested for, looks like possessing multiple fake IDs, and this is a recommitment to custody. Okay, so it looks like they came off the bond, and you currently have a bond amount of $500 on this case. So it looks like you posted a bond and the bondsman came off the bond, endorsed the bond. All right, so you've got a $500 bond.
I think there were two cases.
Oh, I'm
Your
sorry,
Honor.
you got multiple. All right, so you got a second case, that's driving with suspended license. That's also got a $500 bond. So it's two $500 bonds, and I'll appoint the public defender in both cases to represent you. Good afternoon. Your name, please?
I'm Janae Allen.
Ms. Allen, you're here for initial appearance. All right, you've been arrested for driving while license revoked as a habitual offender. Okay, and you got a $2,500 bond. Also for fleeing or attempting to elude. Okay, on the fleeing or attempting to elude, that bond's gonna be set at $2,500. You were also arrested for attaching a tag not assigned to a vehicle. That bond's $250. I'll appoint the Office of the Public Defender in those three cases, currently out on bond from December on a charge of operating a motor vehicle without a valid license. What's your position on that, State? Let's see.
Your Honor, it's related to the offenses today, but she has next to no history. If I could ask the court to revoke and double, please.
Defense, do you wish to be heard? regards to that?
You are inclined to revoke, Your Honor. I would ask that you revoke and double as opposed to holding for no bond, given the very limited criminal history.
Okay. All right, I am going to revoke that bond, and I'll double it to $1,000. And I'm going to order no driving without a valid license.
Okay, can I ask you a question?
Why don't you ask the attorney first? Good afternoon, sir. Your name, please? What's your name, please?
Burton, Earl Burton, sir.
Mr. Burton, you're here for initial appearance. You've been arrested pursuant to a warrant for burglary of a structure and grand theft. Bonds have been set at $3,000 on count one, $1,000 on count two. In addition, you're ordered not to return to 2500 Discovery Drive in Orlando, and no contact with the victim, any co-defendant or witness in the case. Public defenders appointed.
And Your Honor, my client can't afford a monetary bond. Could you ROR in this case?
Well,
Because he's on mental health issues.
Well, the 13 failure to appears, I'm not gonna ROR him. So here's, hold on, I wanna explain why I'm doing it. You got multiple failures to appear in the past, so you're not a safe bet that you're gonna show up for court. So what I've done is I've appointed you an attorney. That attorney can file a bond motion with the judge downtown, and that judge may consider RORing you. This time, I'm not gonna ROR you.
Sir, the court, I'm already in the court system. The doctor found me in Compton. I'm already going through this. I got to go through this for 5 years. And I live in Tampa, sir. I got stuff that I got to get back to. I can't burn out, for one thing. The court would not let me burn out. They would not let me plea out or none of that anyway. So they got to release me anyway. If you should notice this in the system, I cannot burn out.
All right.
They won't let me burn out, and they won't let me make no plea because the doctor already found me in Compton.
Well, I'm not gonna ROR you on the case. If you're able to post a bond, you can bond
Sir,
out.
you're not listening. I can't burn out. The court won't let me burn
I've
out.
heard what you said. Good luck.
I'm telling you, goddamn.
Lot, Sheriff, gave you, Your Honor.
Your Honor, I will waive the appearance. I just had a PC as to the aggravated assault.
Okay.
Based on the affidavit, he threatened to shoot, but there was no gun that was ever pulled. And based on the officer's statement at the bottom, I believe he meant to charge my client with aggravated assault as opposed to aggravated assault with intent to commit a felony. It just says he reached in his pants as if he was going to grab a gun and advised he would shoot. However, there was no gun ever recovered. The victim does not state she saw a gun.
All right, state.
There is not a gun, Your Honor, but it does state that he picked up a stick and threatened to shoot. So he did not have the ability to shoot, but he definitely had the ability to harm.
That's why I said assault, just regular assault. Ortega, they need you.
I would say the aggravation would be the stick, Your Honor. It doesn't state with a weapon, it just says aggravated, and I would say that the stick could be used as a weapon, and therefore it would rise to the level of aggravated.
And if you look at the last statement written by the officer, Your Honor, he does not even mention the weapon. He says, he cites the assault statute, stating that he intentionally unlawfully threatened or by word or act to do violence. I believe this is just a regular assault.
Yeah, it appears that based on that, the subsection that was filed. Seven.
And then as far as this, I would argue no, that the stick is not a deadly weapon, Your Honor. It has to, if used or threatened to be used in its ordinary and usual manner and design, be able to cause death. I don't believe there's PC for the aggravation. It has to be a deadly weapon.
It's usually a jury question. Your Honor, I will agree that the wrong subsection is listed. B is with an intent to commit a felony, whereas A would be with a deadly weapon. I would say it should be A, but I don't believe that defense is going to agree with that.
021 is the aggravated assault statute at 1B. So if it's an aggravated assault with it, what it's charged is with intent to commit a felony. So I don't believe I can. I don't know that I don't think I can amend the charge. I don't think I can find probable cause for it. I think for a lesser I could, but not for the charge. So if he arrests under the wrong subsection of the statute, I don't know that I can. I don't think I can change that.
No, Your Honor, I was looking at with a deadly weapon, not the assault was made with a fully formed conscious intent to commit a felony. So I was looking at the firearm as a deadly weapon.
Well, I mean, with the intent to commit a felony. So if there's a.
Correct.
Could it be, an assault to, and then brandish a weapon? I don't know that that's a felony. Could be a felony if he's a convicted felon. So. Which he is. So, I think I would find that there's certainly probable cause for misdemeanor assault. If the state's asking for 24 hours, we'll reset it.
Yes, please. Well, no, Your Honor. Simple assault would be fine.
So I'll find probable cause for assault. I'll set the bond at $1,000, and that's. I'm not going to give you the statute. Sorry. 784.
I think it's .011.
That's right, 011, 784.011. I'm going to order no contact with the victim, Mary Page, possess no weapons or firearms, maintain a separate residence.
Do they know each other?
All right. Good afternoon, sir. Your name, please?
My name is Carlos Ruben Daniel Jerónimo.
All right, sir, you're here for initial appearance. You've got a couple of cases. All right, let's see. I will appoint the public defender in both cases to represent you. First case, you were arrested for possession of fentanyl. Count 2, possession of cocaine with intent to purchase. Possession of cocaine with a weapon, possession of methamphetamine with a weapon, possession of drug paraphernalia, possession of a weapon by a convicted felon, possession of more than 20 grams of cannabis with a weapon. The bonds have been set at $1,000 on count 1, $15,000 each on counts 2, 3, and 4, $1,000 on count 5, $4,000 on count 6, and $15,000 on count 7. You're arrested on a separate case, resisting an officer without violence. That bond set at $500.
Your Honor, as far as the first case, would you consider treating counts 3 and 4 as subsidiaries?
Okay.
It has 15,000 on one, 15,000 on another, 4,000.
State what's your position on that?
State has no objection to 3 and 4 being subsidiaries, Your Honor.
Okay, so I'll reduce counts 3 and 4 to $1,500 each. Okay, I'm going to order you to possess no weapons or firearms. All right, and I've appointed the public defender in both cases. All right, good luck. Good afternoon, sir. Your name, please?
Warren Detreville.
Sir, you're here for initial appearance. Okay. Been arrested pursuant to a warrant for robbery with a firearm and aggravated battery with a firearm. I'll appoint the public defender. I'm going to stay the bond at none on count 1. Count 2, the bond set at $3,500. Order no contact with any victim, witness, or co-defendant in the case. Possess no weapons or firearms. All right. Good luck, sir. Good afternoon, ma'am. Your name, please?
Nikita Gathers.
All right, Ms. Gathers, you're here for initial appearance. You've been arrested pursuant to a warrant for grand theft. Bond is set at $3,500. I'm going to appoint the public defender. I'm going to delete the pretrial release condition. I am going to order that you not return to the scene to have no contact with any victim or witness in the case. Good afternoon, sir. Your name, please?
Good afternoon, sir. Antoine Henderson.
Mr. Henderson, you're here for initial appearance. Been arrested for burglary of a structure, resisting an officer without violence, criminal mischief, more than $1,000, and trespass in a structure. All right. I'm going to appoint the public defender. Bond set at $3,500 on count 1, $500 on count 2, $1,000 on count 3, and $250 on count 4. I'm going to order that you not return to the St. Mark Free Methodist Church, 1001 Grand Street. While this matter is pending, also that you not have any contact with any victim or witness in the case. Good afternoon, ma'am. Your name, please?
Carla Rosario.
Ma'am, you're here for initial appearance. All right. You've been arrested for grand theft of a motor vehicle. You've also been arrested for failing to appear the status hearing February 21st on a charge of petty theft of $100 or more. The grand theft bond is set at $2,500. And on the failure to appear, the bond is set at $2,000. I'll appoint the public defender in both cases. All right. Good afternoon, sir. Your name, please?
Sir, my name is Cedric P. Jones, sir. Sir, when you go to the chart, is there any way I could just address 1 minute, sir? I know you're very busy. This is vital too, sir, with what's going on.
Okay. You've got the right to remain silent. I'm going to appoint the public defender to represent you.
Yes, sir.
You're here for initial appearance.
Yes, sir.
You were arrested for possession of a weapon by a convicted felon,
Yes, sir.
possession of a weapon and commission of a felony, aggravated assault with a deadly weapon, armed trespass, trespass on property after warning.
Sir.
Now, understand, you, like I said, you got the right to remain silent. Hold on. I'll give you a chance to talk if you want to. But you got the right to remain silent. I've appointed an attorney to represent you. The attorney's gonna say, don't talk, because it's not gonna do you any good. Today's not a trial.
Yes, sir, I know.
Today's just here, I'm here to tell you why you're in jail, and we're here to set a bond, or other conditions of release.
Yes, sir. This is the cop that arrested me, sir. I just got out of jail for aggravated assault with a firearm from this same cop that got dropped 20 days later. So I've been out of jail for 6 days, sir. And the cop that comes to this is the same arresting cop. And like I say, I used to stay at this property, and I got 2 trespassing warrants at this property, so I know not to come onto the property. And I called 911 to help me about the situation with my girlfriend. The 2 ladies said, I'm finna go find my girlfriend, I'll be back. Me and the landlord came out, and we just started arguing, and they called the cops. And this guy came, and it all went
You
haywire.
understand, all this is being recorded.
Yes, it's cool.
It's not gonna make a bit of difference today, because I'm not here, that's what trials are for.
Yes, sir.
The police officer and witnesses show up, and if you want to testify, you can testify, and that's, somebody else sorts it out that day. Today's not the day to sort it out.
I just lost everything that I owned and everything behind this cop, sir, and these charges got dropped. I can't keep losing like this.
We're not here on those charges that are dropped. We're here on,
These are more fraudulent charges. I can't keep losing.
okay. All right. All right, State, do you have a position on bond?
He's entitled to a bond, Your Honor.
Okay. He's out on ROR on, looks like 2 drug cases that doesn't appear those have been filed on yet.
No, Your Honor, they've both been filed on.
Oh, they have been filed on, okay.
That's why these guys give me all these heinous charges, sir, because he's no amount on these bonds. That's the same thing he did last time. And he give me, I had a wrench in my hand, sir, and I'm across the street. And No, I'm not admitting to no crime. I did no crime. I didn't even go on his property. I'm talking to this guy in the street, and they give me all these heinous charges, and I just stay there.
Okay, all right. Defense, do you wish to be heard with regards to bond?
I would just ask for reasonable bond, Your Honor.
So I never stepped 1 foot on this guy's property. Not 1 foot. I'm all the way across the street.
All right, I'm gonna set the bond at, these.
These are heinous charges, sir. Violent charges. The same cop keep throwing on me because he know I have a pass and I'm not doing nothing. I'm talking to this guy across the street, and he's at his front door, and all this stuff happens. I don't know how.
I don't know how.
And the owner has a gun, and he tell me, if you approach me, I'm gonna blow your head off. I did not step 1 foot on his property. I'm all the way across the street, and I called the cops first to get help. And now I'm thrown in jail. I called the cops first. 2 lady cops come. They said, we're finna go look for your girlfriend. We started arguing. He called 911. The other cops come, and everything changes. Now I got all these heinous charges on me. I had no weapon. I was fixing my bicycle with a little itty bitty wrench. This man has a gun on me. So how am I coming for assault? And I'm across the street. I did not step 1 toe on this property. I got 2 trespass warrants from this place already. I know not to come on property. I'm not trying to go to jail. I'm trying to do the right protocol. I'm all the way across the street. The cops even find me in the street, waving them down where I'm at. And I get all these heinous charges. The cop is wicked, man. And I can't keep losing. I lost everything behind that charge he put on me, sir. I lost everything.
Okay. All right, so I'm gonna set the bond on count 1 at $5,000. Counts 2, 3, and 4 will be stayed at 150. Count 5 at 100. Order no return to the scene, no contact with any victim or witness in the case, possess no weapons or firearms. I'm going to revoke the RORs that he's out on. Looks like you got a pretrial on Monday.
This is gonna kill me right here, sir. I never stepped foot on this guy's property. How you doing this to me, sir?
All right. Well, I've appointed you an attorney, so.
Oh man, I can't keep going.
Good luck.
I apologize, Your Honor. Was that revoke on both or just the one that's?
Both.
Okay.
Both.
I just got these back, sir.
Good luck, Mr. Jones. Yes. No bond on both. How does that happen? Well, yeah, revoke the RORs on both. Yeah, they've both been filed on. He's got court coming up. Good afternoon, sir. Your name, please?
Jack Kilefner.
Mr. Killeffer, you're here for initial appearance. You've been arrested for failing to appear at a pretrial conference back on January 24th on charge of possession of cocaine. The judge set the bond at none. All right, good luck. Good afternoon, sir. Your name, please? Mr. Lamb, you're here for initial appearance on two matters. You've been arrested first for failing to appear for a trial management conference on November 1st last year on charges of possession of a controlled substance and possession of drug paraphernalia. And the judge set the bond at none. You were also arrested for failing to appear for a pretrial in January this year on a charge of possession of cocaine. The judge set a bond at $1,000 in that case. Good luck.
Longstreet, refuse.
Defense will waive, Your Honor.
Mr. Longstreet, I'll appoint the public defender. I'll stay the bond at $10,000. Order no contact with any victim, witness, or co-defendant. Possess no weapons or firearms.
And no return also, Your Honor.
No return to the scene. Good afternoon, sir. Your name, please?
Andrew James Ferris, Your Honor.
Mr. Ferris, you're here for initial appearance. You were arrested for failing to appear at a plea hearing on February 14th this year on a charge of possession of a controlled substance. The judge set the bond at none. All right, good luck.
So what do I do?
I'll appoint an attorney to represent you. I believe one was already appointed. I will appoint the public defender to represent you.
Have time served?
We can't plea out on felonies.
Have a reinstate my bond, please?
I'm not gonna do that.
Please, Your Honor, please reinstate my bond, please.
You can ask, please. That doesn't change. The answer is no. Good afternoon. Your name, please?
Andre.
Wait, did I give you both? That last one, is that the right one? Yeah? Okay, all right, so, I'm sorry, what was your name?
Andrea Pugh.
Pugh, I thought I heard you right. I don't have an Andrea Pugh. Is it stuck to one of those?
It's a failure to appear, Your Honor.
Yeah. Did it get? My next one is John Randall. Yeah, Pugh, I just lost the paperwork got. There, I'm sorry, it was a couple down. Okay, we're straight now. All right, Ms. Pugh, you're here for initial appearance. You were arrested for failure to appear on a possession charge, saying you missed your arraignment back on January 17th of this year. The judge set the bond at none. I'll appoint the public defender to represent you.
So I have no bond, sir?
You've got no bond, but I've appointed you an attorney. The attorney can file a bond motion with the judge. All right, good luck. Good afternoon, sir. Your name, please? Mr. Randall, you're here for initial appearance. You were arrested for failing to appear for a status hearing back on February 8th on a charge of possession of a controlled substance. The judge set the bond at none. Good luck, sir. Good afternoon, sir. Your name, please?
Octavius Rose.
Mr. Rozier, you're here for initial appearance. You've been arrested for possession of a firearm by convicted felon, trafficking in methamphetamines greater than 28 grams with a weapon, and possession of ammunition by a convicted felon. Okay. And state, is he entitled to a bond on count 2?
He is not, Your Honor, because it is a first-degree felony, and then with the gun, it raises it to a punishable by life. However, it is on the bond schedule, and if you give me a moment, I think I can find it. With a weapon, Your Honor, it would be $100,000.
Does the defense wish to be heard with regards to bond?
I just asked that you set a bond. I believe the state just stated that it's $100,000, Your Honor. If you set that count at $100,000, I'd ask that you treat the remaining counts as subsidiary.
All right, I'll set the bond in count 2 at $100,000. Count 1 will be subsidiary. I'll set it at $1,500. And count 3, I'll set subsidiary at $1,500. Order that you not possess any weapons or firearms.
I'll just make sure we're not like. Yeah, it's complicated.
Good afternoon. Your name, sir?
Elijah Smith Jr.
Mr. Smith, you're here for initial appearance. You've been arrested for possession of MDMA, purchase of MDMA, and resisting an officer without violence. I'm going to appoint the public defender to represent you, and you're also currently out on bond for possession of MDMA, or out on ROR. Okay. So on count 1, I'll set the bond at, it'll be set at 1,000, count 2 at 15,000, count 3 at 500. State, you have a position on the out on bond?
Your Honor, he was arrested January 30th. As of today's date, formal charges have not been filed. You can take no action.
I'll take no action on the out on bond.
Your Honor, I would ask that you consider reducing count 2 to 15,000. This appears to be more of drug use as opposed to drug sale, so I would ask that you reduce that bond amount to 5,000, Your Honor.
So,
No objection, Your Honor.
I'll reduce the bond to count 2. I can get back to it here. I'll reduce it to 7,500. Good afternoon. Your name, please?
Andy Smith.
Ms. Smith, you're here for initial appearance. All right, you've been arrested for, this is pursuant to a warrant for dealing in stolen property, false verification of ownership to a pawnbroker, and petty theft. I will appoint the public defender. The bonds have been set at $2,500 on count 1, $100 each on counts 2 and 3. And I'll take no action on the out on bond on the misdemeanor dwellers. Good afternoon, sir. Your name, please?
Gabriel
You have a last name, Gabriel?
Sastre.
Okay, Mr. Sastre, you're here for initial appearance. You've been arrested for fleeing or attempting to elude, neglect of a child, and resisting an officer without violence. I'll appoint the public defender to represent you in this case. State, you have a position on bond?
No, Your Honor.
Defense?
I'd ask that you consider his very limited criminal history, Your Honor, when setting the bond. And he has resided in the Orlando area for well over a year.
Your Honor, the neglect of a child was his little sister was in the car with him.
All right, I'm going to set the bond at $3,500 on count one, $1,000 on count two, $500 on count three. All right, good luck.
James and George is in the hospital.
And if we
Let's,
reset 24 hours.
yeah, we'll reset 24 hours after release from the hospital. Good afternoon, sir. Your name, please?
James Williams.
Okay. All right, Mr. Williams, Mr. Williams, you're here for initial appearance. Somebody out in the
We'll waive the reading.
someone out in the gallery that's,
I think that's his family.
That's my baby mama.
okay,
It's just his family, Your Honor.
okay. All right, so we're here for initial appearance.
So,
All right. And state, based on the nature of the charge, is the defendant entitled to a bond?
He is not, Your Honor.
Okay. All right, so I'm going to appoint the public defender to represent you. I'm going to stay the bond at none. Order no contact with any minor under the age of 18 while this matter is pending. Mr. Williams, your attorney can file a motion with the judge downtown, can have a full-blown bond motion.
I understand. Listen to what I'm saying.
I'm not going to set a bond today. He's not entitled to a bond today. He can have a bond motion with the judge downtown. All right. All right. Good luck. Got 33-day motions. Got Casell Anastasia Hayes, 22 CF 14947.
Denied and information was filed.
Andres Javier Acevedo Vega, 23 CF 1140 AO.
Granted, notice of non-filing.
James Nelson Turner, 22 CF 14758.
Granted, notice of non-filing.
Elizabeth Mendez, 22 CF 14533.
Granted, notice of non-filing.
Antonio Garfield Lemon, 23 CF 778 AO.
Denied and information was filed.
John Fitzgerald Washington Jr., 23 CF 1722 AO.
Denied and information was filed.
Jean Bartholomew, 23 CF 1723 AO.
Denied and information was filed.
Christopher Lejean Burns, 22 CF 14922.
Granted, notice of non-filing.
Mina Bolzort, 22 CF 14601.
Granted, notice of non-filing.
Granted. Mark Joseph Denny, 23 CF 1305.
Granted. Notice of non-filing.
That's granted. Viwi Kus, 23 CF 1719.
Granted. Notice of non-filing.
Granted. Andrew Gabriel August, 23 CF 1634 AO.
Granted. Notice of non-filing.
Granted. Michael Lewis, 23 CF 1695.
Granted. Notice of non-filing.
Granted. Second, Michael Lewis, 23 CF 194 AO.
Granted. Notice of non-filing.
That's granted. Julie Carol Dort, 23 CF 1505.
Granted. Notice of non-filing.
Wesley Keena Rush, 23 CF 1739.
Granted. Notice of non-filing.
Joshua Gabriel Mendez, 23 CF 1287.
Denied and information was filed.
Denied. And Andre Tran Winn, 23 CF 696 AO.
Granted. Notice of non-filing.
Granted. Leonardo Toledo, 22 CF 14706.
Granted. Notice of non-filing.
March. Okay, that's it. We're on recess.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
¿Usted jura solemnemente o afirma que el testimonio que va a dar será la verdad, toda la verdad y nada más que la verdad?
Sí, lo prometo.
Yes, I promise.
Okay. State your name, please.
¿Su nombre, por favor?
Melanie Beriguete.
Melanie Beriguete.
All right, I will appoint the Office of the Public Defender, and Counsel, do you have an argument?
Yes, Your Honor. I would argue no PC as to the assault. Based on Florida Statute 784.011, there must be a threat by word or act to do violence. In this,
Muy bien. Vamos a argumentar que no hay causa probable en cuanto al cargo número 1 basado en las leyes de Florida, ya que tiene que haber una amenaza creíble de violencia.
in this affidavit, it states that there was an argument over the dogs.
En esta declaración jurada indica que hubo una discusión debido a unos perros.
The only thing that's mentioned is a step forward.
Lo único que se menciona fue que alguien dio un paso al frente.
There was no indication that my client had their fist balled, they were pointing their fingers, there was no overt act, Your Honor.
No hay ninguna indicación de que mi cliente haya haya puesto la mano en un puño, se apuntaron con los dedos, no hay ningún evento que sea un acto de amenaza.
So I would argue no PCS due to the assault.
Así que vamos a argumentar que no hay causa probable en cuanto al cargo de agresión.
State, do you have a response?
Le pregunto a la fiscalía si tiene una respuesta.
Sí, estoy de acuerdo.
Le están preguntando a la fiscal.
Your Honor,
Your Honor, the witness indicated that I agree.
Okay. We're not asking the witness questions yet. I'm asking the state at this point. State.
Muy bien, señora, todavía no le están haciendo las preguntas a usted, le están haciendo preguntas a la fiscal.
Your Honor, it is a conclusion, but at the end, it does say the defendant squared her body and took a fighting stance. In addition, it seems as though, I believe it is the father intervened and put the defendant in a bear hug in order to separate the two, to prevent any interaction, Your Honor. So I would say that that is enough for it to be an assault.
Muy bien, su señoría. Y queríamos indicar que es una conclusión, pero al final del documento indica que la acusada asumió una postura de ataque, de pelea, y que entonces ella tuvo que ser agarrada, abrazada por el padre para evitar que hubiera un acto de violencia. Así que nosotros entendemos que eso es suficiente amenaza.
All right. After reviewing the affidavit, the court is going to find that there is probable cause.
Muy bien, luego de revisar la declaración jurada, el tribunal está determinando que sí existe causa probable, motivo fundado.
So I'm going to ask the witness, Miss Melanie Barraget, if Jahami, if I'm saying that right, if she's released, do you want to have contact with her or do you want her to stay away from you?
Muy bien, entonces le voy a preguntar a la testigo, a la señora Melanie Berriguete, si cuando Jehemi, me parece que es el nombre de ella, sea liberada, usted quiere tener contacto con ella o prefiere que ella se mantenga alejada.
Sí, quiero tener contacto con ella.
Yes, I would like to have contact with her.
Are you in fear of her?
¿Usted le tiene temor a ella? ¿Le tiene miedo?
No,
No.
Does the state have any questions for the witness, victim?
No, Your Honor.
La fiscalía no tiene preguntas para la testigo víctima.
All right. Does the defense?
No, Your Honor.
¿La defensa tiene alguna pregunta? No.
And state, do you object to pretrial release?
¿La fiscalía va a objetar que sea liberada la acusada con las condiciones de la oficina de anterior a juicio?
No, Your Honor.
No, su señoría.
Defense?
¿Defensa?
No, Your Honor.
No, su señoría.
I'll release you on pretrial release with the condition that you have no hostile contact with Melanie Barraget.
Muy bien, ella va a ser liberada bajo las condiciones de la oficina de antelación a juicio con la condición que no puede tener contacto hostil con Melanie Berriguete.
I understand.
Okay, all right. All right, so she'll be processed and released today.
Así que ella va a ser procesada y liberada hoy.
Good luck, ma'am.
Thank you.
Le deseo buena suerte.
And that's all we have. Thank you, Mr. Interpreter.
Your Honor, could I have the name of the defendant?
The last one,
Yes.
that case is,
Jahemi Berigati, Jheimy, last name Beriguete.
Okay, I got it.
all right, thank you.
You're welcome, Your Honor. Have a good day.
You too. Good morning. This is Judge Duckworth. Are you able to hear me?
Yes, good morning, Judge, Your Honor. My name is Philip, and I will be a Haitian Creole interpreter today. I am ready for instructions.
Okay. Have you been sworn in?
No.
We swear in our interpreter.
Do you solemnly swear to truly translate from Creole to English and English to Creole the testimony about to be given, so help you God?
Yes, I do.
Good morning, ma'am. State your name, please.
Bonjour, Madame. Qui j'en relais? Marie Betty Oxan.
Ma'am, you're here for initial appearance in case 2023 MM 1637.
May you please repeat the case number, Your Honor?
2023 MM 1637.
Alors, ou vini là aujourd'hui pour première apparition pour cas 2023 MM 1637.
You have been arrested for the offense of battery.
Alors, yo arrêté ou pour tête ou gourmet.
I will appoint the Office of the Public Defender to represent you.
Alors, moi pral assigner un défenseur public pour capable représenter ou.
State, do you have a position on bond and do you object to pretrial release?
Alors, et ou gagne une position, Rovan, pour être capable de laguer ou avant et première audience là.
No objection to pretrial release.
Defense?
No objection, Your Honor. And I would just ask for a one-time return with law enforcement.
I will release you on pretrial release with the following conditions.
Alors, moi pour libérer ou et avant et premier jugement, n'a libéré ou mais avec une série de conditions.
That you have no contact with Javon Henriquez.
Alors, pour pas gagner aucun contact avec Javon Henriquez.
That you maintain a separate residence from him.
Alors, pour vivre dans l'autre caille, séparé de lui-même.
That you may return to the shared residence one time with law enforcement to get your personal belongings.
Ou gen ou a retourner dans caille que ou ta vivre ensemble avec là, on gagne une fois avec la police pour aller retirer affaires personnelles.
Otherwise, you're to have no contact with him.
Alors, à part ça, on va supposer qu'il y a autre contact avec lui.
Okay. Good luck, ma'am.
Bonne chance, madame.
Yes.
Thank you.
Thank you very much, Mr. Interpreter.
My pleasure, and thank you for using our services. Have a wonderful day.
Trying to coordinate branch is behavior.
All right.
Defense will waive, Your Honor.
All right, so I'll appoint the public defender. I'll stay the bond at $500 with an order of no return to the scene. Without a legitimate medical emergency. Hospital.
I gotta get that. And in this case, Your Honor, we have competency issues, so we're not going to resolve it today.
Okay. All right. Good morning, sir. Your name, please?
Taylor, Michael Taylor.
Thank you, Mr. Taylor. You're here for initial appearance. You were arrested for a trespass after warning. I'm going to appoint the public defender to represent you. Your bond is set at $500 with an order not to return to the Lynx bus station, 455 North Garland Avenue. All right. Good luck, sir. Good morning, ma'am. Your name, please?
Haley Carula.
Ma'am, you're here for initial appearance. I'm going to appoint the public defender to represent you. You've been arrested for the offense of prostitution and resisting an officer without violence.
No PC arguments, Your Honor. State provided a statute.
Okay, and I'll stay the bonds at $500 on count one, $100 on count two. Okay. Good luck.
So how much do I need?
200.
Good morning, sir. Your name, please?
Jack Bass.
Mr. Mask, you're here for initial appearance. Been arrested for obstructing justice by hindering communication with law enforcement and battery with a prior.
Your Honor, I have PC as to the obstruction.
Okay.
I see.
I am going to appoint the public defender, and there's a witness. We'll swear in the witness.
Ma'am, please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Good morning, ma'am. Your name, please?
Mariana Hennings.
Ms. Hennings, okay. All right, defense, you have a PC challenge?
Yes, Your Honor, only as to the obstruction of justice. It appears, based on this affidavit, that there's no indication the victim was in the process of dialing 911 at the time my client allegedly took the phone. It just states that they were arguing and he snatched the phone out of her hand and grabbed her cell phone from her and broke it, but no indication that she was trying to reach out to law enforcement at the time. So I'd argue no PC as to the obstructing justice, Your Honor.
State?
No objection.
All right. Okay, then I'll find no PC as to count one. On count two, the battery with a prior, ma'am, if Mr. Mask is given a bond, otherwise released, do you want to have contact with him or do you want him to stay away from you?
I want him to stay away.
Okay, all right. All right, State, do you have any questions for Ms. Hennings?
No, Your Honor.
All right, defense?
No, Your Honor.
All right. And State, what's your position on bond?
Mm-hmm.
Do I do pre-trial or?
No position, Your Honor.
You don't qualify.
All right, defense, what's your position on bond?
Your Honor, I would ask for $1,000 bond. Based on the affidavit, it states that there may be some sort of mental condition. So I just ask that you consider that.
It's a brain injury.
Yes, a traumatic brain injury. So I just ask that you consider that when setting the bond. I would, I don't believe he could, but I would ask for a bond or mental health pretrial release if he could qualify.
All right, I'll set the bond at $1,000 or mental health pretrial release if you qualify with the following conditions: that you have absolutely no contact with Mariana Hennings, and that you maintain a separate residence. Ma'am, are you living at that Lee Road apartment?
Yes,
Okay.
and my kids are there as well, and
All right, so you're not going to be able to live at that Lee Road apartment address. You can return there one time, but you have to be escorted by law enforcement. You're not to go back there alone. You're not to have contact with her. If you go back there, if you have contact with her and the court's made aware, expect, number one, you'll probably get rearrested, and you'll probably sit in jail on no bond, okay? So absolutely no contact, either directly or indirectly. Also, that you comply with any orders of the Department of Children and Families. It appears they were called. All right. That you possess no weapons or firearms, consume no alcohol or unprescribed medication. All right. Okay. All right. Thank you, ma'am. ROR on count one.
I know James Gibson is in hospital.
Gibson.
Your Honor, in this particular case, can we
Yeah, we'll reset Gibson to tomorrow. If you think you can get it resolved, that's fine.
I do. I don't see any issue.
On Hershey Hospital, Your Honor.
And I will, I will waive, Your Honor.
All right, so I'll appoint the Office of the Public Defender, stay the bond at $1,000. I'll take no action on the Osceola County out on bond.
Michelle McCormick Hospital, Your Honor.
Defense will waive, Your Honor.
MacArthur, I'll appoint the Office of the Public Defender on the aggravated assault. State, you have a position on bond?
Your Honor, I would just take note that he does appear to have extensive history and is, at this time, also on probation.
Okay. All right, defense?
Just a resolve on, Your Honor.
Okay, looks like he's,
Looks like they added an on view. Yes, okay.
Yeah, he's here on the on-view as well today.
yep. Okay, on the aggravated assault, I'm gonna set the bond at $7,500. Count 2, I'll stay at 500. Count 3, set at 500. Order no victim contact, possess no weapons or firearms. And on the on-view violation, I'll stay that at none. Good morning, sir. Your name, please?
Quantavious Mitchell.
Mitchell, you're here for initial appearance on 2 cases.
Oh, God.
And we've got so you were arrested pursuant to a warrant for aggravated child abuse in 23 CF 2953, and you were also arrested in separate case number 23 CF 3107 for aggravated battery, domestic related, and obstructing justice by hindering communication of law enforcement. Okay. Come on, killing me here. Can we swear in the witness?
Please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, good morning, ma'am. State your name, please.
Alicia Stewart.
Sir, could you speak up just a little bit?
Alicia Stewart.
Thank you. All right, Ms. Stewart. All right, this is on the second aggravated battery, battery domestic related, okay. Ms. Stewart, if Mr. Mitchell is given a bond, it appears he was entitled to a bond. If he's given a bond and is able to post that and is released, do you want to have contact with him or do you want him to stay away from you?
Yes, have contact.
You got to speak
Yes,
up.
have contact.
Okay. Are you in fear of him?
No.
State, do you have any questions for Ms. Stewart?
Good morning.
Good morning.
Do you have custody of your children?
Not at this moment.
Okay. No, I have no further questions, Your Honor.
Does the defense have any questions?
No, Your Honor.
Okay. State on the second case, what's your position?
Would that be the aggravated child abuse, Your Honor?
No, I'm sorry, the second case is the aggravated battery and the obstructing justice by hindering communication.
He's entitled to a bond, Your Honor, and he has arrest but no conviction. So whatever standard the court would give you.
Okay. All right. Defense?
I would argue the same, Your Honor. Although he has an arrest, he has no convictions on his record, so I'd ask that you consider that when setting the bond today.
Okay. All right, so in 23 CF 3107 AO, the aggravated battery, I'm going to set the bond at $2,500 on count 1, $500 on count 2, and $500 on count 3. I'll order no hostile contact with Alicia Stewart, possess no weapons or firearms, consume no alcohol or illegal drugs. Okay, on the aggravated child abuse in 23 CF 2953, state you have a position on bond in that case.
Your Honor, I would ask for at least $15,000. The allegations are particularly egregious. Yeah, they're particularly egregious, and I think that's the only jurisdiction I have with regard to the amount of bond, and obviously that he had no contact with the children.
Okay. Defense?
Your Honor, I'd ask for a lower bond than that, maybe $5,000. He has no criminal convictions. The child is no longer in the home. The child in DCF custody, which would prevent any further altercations. And if you made in a condition of his release that he has no unsupervised contact with any minor child, I think that would prevent any further issues from occurring.
I'll set the bond at $10,000. I am going to order that you have no contact with the minor, Jordan. Obviously, maintain a separate residence from the child in that case, and that you comply with any orders of the Department of Children and Families.
Yana Victoria Waters, refute.
Your Honor, I will waive. I would just argue no PC as to the second violation. There's no indication in the affidavit that there was, in fact, she was convicted of a second prostitution. So I would just actually find PC for the first offense.
Okay. State?
No objection, Your Honor, and instead of it being 101, instead of it being dash 101, it should be dash 100.
So it's 796.07, subsection 2, subsection E, dash 100. Sure. 796.07, sub 2, sub E is an egg, dash 100. And I'll reduce the bond to $250. And I'll appoint the public defender.
It's just prostitution.
Yep. Good morning, sir. Your name, please?
Gene Etienne, sir.
All right, Mr. Etienne, you're here for initial appearance. You've been arrested for aggravated battery on a pregnant person, also battery by strangulation, domestic related. I will appoint the public defender in the case. State, you have a position on bond.
No, Your Honor.
Defense?
I just ask that you consider he has no criminal history, not even arrest, Your Honor, when setting the bond, and defense would ask for a one-time return with law enforcement.
All right, I will. I'm going to set the bond at $5,000 on count 1, $1,500 on count 2. I am going to order that you have absolutely no contact with Magdalene Carmoga. I'm saying that right? You're to have absolutely no contact with her. You're to maintain a separate residence. If she's living at that Lee Vista Boulevard apartment, you're going to have to live somewhere else. You can return there one time, but you have to be escorted by law enforcement. You're not to go back there alone. You're not to have any contact with her. Possess no weapons or firearms. Consume no alcohol or illegal drugs. All right, good luck. Good morning. Your name, sir?
Rowan Hardiel.
Mr. Hardiel, you're here for initial appearance. You've been arrested for aggravated battery with a firearm. I'm going to appoint the Office of the Public Defender to represent you.
I want to.
Oh, hold on. You have the right to remain silent. I've appointed you an attorney, so if there's something you want to say, you should run it by the attorney first.
Thank you, Your Honor.
All right, State, you have a position on bond?
No, Your Honor.
Okay, defense?
And I just ask that you consider that he has no criminal history, and I would also ask for a one-time return with law enforcement to gather any belongings.
I'm going to set the bond at $5,000. I will no contact with the victim. You can return to the residence one time with law enforcement to get your personal belongings. Otherwise, no contact. Order that you possess no weapons or firearms. Good luck. Good afternoon, sir. Your name, please?
Clifton Hill.
Mr. Hill, you're here for initial appearance. You're going to appoint the public defender. You've been arrested for obstructing justice by hindering communication with law enforcement, aggravated battery with a deadly weapon, it's domestic related, and battery by strangulation. And it also appears that you're out on bond. Okay. All right. State, you have a position on bond?
No, Your Honor.
Defense?
I just asked for a reasonable bond and a one-time return with law enforcement, Your Honor.
All right, I'm gonna, on count one, I'll set the bond at $1,000. Count two, I'm gonna set the bond at $5,000. Count three at $1,000. I'm gonna order no contact with the victim, that you maintain a separate residence. You can return, it actually shows different address, but if it's a shared address, you can return one time, but you have to be escorted by law enforcement to get your personal belongings. You're not to go back there alone, not to have contact with the victim, or to possess no weapons or firearms. All right, good luck.
And on his out on bond, Your Honor?
I'll take no action on the out on bond.
That's what I was waiting for.
Jacob Johnson, Your Honor, behavior.
We'll reset Jacob Johnson to tomorrow.
Your Honor, I will waive the appearance.
Okay, all right. And Jacob Johnson, I'll appoint the public defender.
I would ask for a one-time return with law enforcement. It appears they do reside together, Your Honor, and he does qualify for pretrial release. He has no convictions or arrests, so I would ask for pretrial release.
Okay. State?
No objection.
Okay, I'll release him on pretrial release with the condition he have absolutely no contact with Destiny Ortiz, maintain a separate residence, can return one time with law enforcement, not to return alone, possess no weapons or firearms, no alcohol or illegal drugs. Morning, your name, sir?
Jason Rivera.
All right, Mr. Rivera, you're here for initial appearance. I'm going to appoint the public defender to represent you. State, do you have a position on bond?
Your Honor.
Defense, you have a position on bond?
I would ask for a reasonable bond, and Your Honor, they did reside together, so a one-time return with law enforcement.
apologize for interrupting. What case number do you have for this?
Excuse me?
What case number do you have for this case?
2023 CF 2548 AO.
Oh, okay, that's not what I have. Thank you.
Okay. On the battery by strangulation, I'm going to set that bond at $7,500. The false imprisonment, I'll set at $1,500 and the battery at $500. I'm going to order absolutely no contact with the victim, Miss Escalera, Jennifer Escalera, that you're to maintain a separate residence from her. That if she's still at that, it appears it's maybe a hotel or motel, South Orange Blossom Trail. If you have personal belongings at that address, you can return one time with law enforcement to get the personal belongings. You're not to go back there alone. You're not to have contact with her. Possess no weapons or firearms.
Thank you, Your Honor.
Good luck.
And I did have PC.
All right. All right. Good morning, sir. Your name, please? Mr. Smith, you're here for initial appearance. I'm going to appoint the public defender to represent you. You've been arrested for domestic battery by strangulation. And we've got a witness. Could we swear in the witness, please?
Ma'am, please raise your right hand. Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Good morning, ma'am. State your name, please.
Yvonne Sadler Smith.
All right, ma'am. Thank you. And what's the probable cause challenge?
I would argue no PCS to the battery by strangulation, Your Honor. Based on the affidavits, there was no indication that the alleged victim's breathing was restricted or impeded in any way, so I would argue no PCS to the battery by strangulation.
State?
No objection.
Okay. All right, so the court will find probable cause for battery. All right, and Ms. Smith,
Excuse me.
if DeAndre Smith is released?
Excuse me, sir.
Yes, ma'am.
I had my husband ex parte, okay, on the 7th. This happened the 8th. My husband Baker at 4 times. My husband supposed to be on medication in here. He told them, I took him to a psych. My husband never was like this. My husband needs a psych evaluation. That's what this is for. The judge signed this on the 7th to get him a psych evaluation. He talks to himself. He's not sleeping. I don't know if it's drug related. He used to do drugs way back in the day, cocaine. He stopped when he got with me. We've been together for 17 years.
Okay.
My husband has never assaulted me. I'm not really afraid of him, but he needs a psych. He needs help.
Okay.
They release him after 2 days. He won't take the medicine. I am a nurse. I asked them to give me injections for him. They will not. They saying he still has his rights. They told me I have to get an attorney to be over him, to be his guardian. And I went down there, and the sheriff's department was supposed to pick him up so they can get a psych evaluation on him.
Okay.
It's
Okay. All right, so and do y'all have a stable residence?
No, this is what happened. I was traveling, I came back.
We don't need to get into the minutia of it.
We stay in extended stay, but they kicked us out the first one because he went off.
We don't need to get into the why. Okay. So one thing that we can try to do is we can try to have him screened for a mental health pretrial release, and they can do an evaluation. We can't solve all the ills of a problem. This is just an initial appearance. So I tell him why he's charged. We try to work out a condition of release, okay? So I can release him on a bond or mental health pretrial release. So unless he's able to post the bond himself, he's gonna have to rely on somebody else to do it. If he's gotta rely on someone else, then you can let him go through in the mental health pretrial release. They'll make a determination. They'd probably contact you to try to make a determination if there's got some type of stable housing and other conditions that they require to do that. But that's kind of set up to try to help people with mental health issues while on release, while the case is going on. That's all I can address at today's. So let me ask the state, do you have any questions for Ms. Smith?
Ma'am, I understood you to say that you are not afraid of him. However, do you still want to have contact with him?
Yeah.
And by any chance, do you know his date of birth?
6/21/77. He's 45 years old.
Thank you. I have no further questions, Your Honor.
Okay. Does the defense have any questions?
No, Your Honor.
Okay. All right, so I'm going to set the bond at $500 or mental health pretrial release. So, and they'll interview him, and they may reach out and try to contact you. Okay, so I'll order no hostile contact with you, mental health pretrial release. I'm also going to order that you take all medication as prescribed, sir. Okay? All right, good luck. The battery is, what's that, 784.03?
Yes, -10.
-10.
Octavius Stephen in the hospital.
Can we reset 24 hours from release of the hospital, Your Honor?
Yep, Stephine, reset for 24 hours after release from hospital. Good morning, sir. Your name, please?
Steiner Slade.
Mr. Steiner, you're here for initial appearance. You've been arrested for a battery by strangulation that's domestic related. At this time, are you asking me to appoint an attorney to represent you in this case, or are you going to hire an attorney, sir?
I'm going to hire an attorney, sir.
Okay.
For Your Honor.
All right. State, you have a position on bond?
Hey, Your Honor. Oh, he does qualify for pretrial release.
All right, if you qualify, I'll release you on pretrial release with the conditions that you have absolutely no contact with the victim. You maintain a separate residence. You can return to the shared residence one time with law enforcement escorting you to get your personal belongings. You're not to go back there alone, not to have contact with the victim. Order that you possess no weapons or firearms, consume no alcohol or illegal drugs.
Yes, Your Honor.
All right, good luck.
Thank you, sir.
Good morning, sir. Your name, please?
Manel Sylvester.
Mr. Sylvester, you're here for initial appearance on a couple of cases. I'm going to appoint the public defender in these cases to represent you. First case, you were arrested in 23 CF 3106 for fleeing or attempting to elude, possession of more than 20 grams of cannabis, possession of cocaine, and resisting an officer without violence.
And Your Honor, I had a PC only as to the possession of cocaine.
Okay, go ahead.
I would argue no PC as to the possession of cocaine. The cannabis was tested, however, the cocaine was not. But I typically find no PC for that charge.
And state?
It wasn't tested, Your Honor, so no correction.
All right, so on the fleeing or attempting to elude, I'm going to set that bond at $2,500. The count 2 cannabis stayed at $1,000. Count 3 possession of cocaine, I'll find no probable cause, and I'll ROR you on that count. And resisting an officer without violence, I'm going to reduce that to $500. Okay. Now, you also were arrested for in 23 CF 3105 for battery by strangulation. It's domestic related, battery, petty theft, and criminal mischief. And we've got a witness to swear in the witness.
Please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth? Yes. Answer out loud.
Yes.
Thank you.
Good morning. Your name, please?
Kayla Thurston.
All right, Ms. Thurston. If if Mr. Silvestri is released in this matter, do you want to have contact with him, or do you want him to stay away from you?
I have to. I have his daughter at my residence, and she's there up until the summer, I think, of June of 23.
Okay. So if I understand what you're saying, and I don't want to put words in your mouth.
Yes, I do, because I have his daughter as well, and then my daughter who's 10, which we have not established paternity for her.
Okay. So are you, well, let me ask you this. Are you in fear of him?
No.
Okay. All right. State, do you have any questions?
No, Your Honor.
Okay. Defense, do you have any questions?
I do not, Your Honor. Defense would just point to the fact that he does qualify for pretrial release. I would ask for pretrial release in this case, Your Honor.
Okay.
Wait, I apologize, Your Honor. I do have a question. I apologize. Ma'am, does the defendant live with you?
He does not. His daughter is there, I would say, every day, but he comes maybe the max twice a week, because I work 6 a.m. to 2 twice a week. So he's there to transfer her to school.
Okay.
Okay.
All right. So what I'll release him on pretrial release on the domestic case with the condition that he maintain a separate residence, have no hostile contact with you, that he consume no alcohol or illegal drugs, possess no weapons or firearms. All right. Okay?
Okay.
Thank you. Morning, sir. Your name, please?
Diana and Tulsa Ram.
All right, sir, you're here for initial appearance. I'm going to appoint the public defender to represent you. You've been arrested for kidnapping and battery.
Your Honor, defense would argue no PCS to the kidnapping.
Okay.
In order to have a kidnapping based on Florida statute 787.01, the actual kidnapping, the actual confinement, adjustment, or imprisonment must not be slight, inconsequential, or merely incidental to the felony, which is the battery. It must not be the kind inherent in nature of the felony. It must have significant independence of the felony. Based on the facts in this case, it appears that both my client and the victim reside together. The affidavit states that the victim was intoxicated at the time, and that they drove off together because they lived together, Your Honor. There's no indication that he abducted her in order to commit a crime other than the battery he was already committing, Your Honor. So I'd argue no PC as to the kidnapping.
State.
Your Honor, they lived together at the extended stay. However, he was seen by an independent witness, and then the police, through physical evidence, were able to corroborate that the victim was dragged through a parking lot, dragged into a vehicle, dragged through the vehicle, all resulting in physical injury. And the battery didn't, from what I can remember, did not take place at the extended stay. It took place within the vehicle. So I would say that the dragging and the moving away was not inconsequential, Your Honor. And the dragging and the moving away was to make it easier to batter the victim.
No, Your Honor, I would disagree, Your Honor. The officer stated that in the back of the truck there was disarray. However, the battery from my reading was the choking and dragging her across the parking lot was what I gathered from the affidavit. The officer stated he assumed that's what he was going to do.
Okay. The 1A, 1, under the kidnapping statute, kidnapping means forcibly, secretly, or by threat, confining, abducting, or imprisoning another person against his or her will without lawful authority with intent to, under subsection 3, inflict bodily harm or to terrorize the victim or another person. So I think based on the allegation alone, I think that that's sufficient probable cause, so I'm going to deny the probable cause challenge. All right. And let's swear in the witness.
Ma'am, do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Good morning, ma'am. State your name, please.
My name is Lisa Mohaber.
All right, ma'am. I see you're listed as the victim, ma'am. If Mr. Tulsa Ram is granted a bond, is able to post it and he's released, do you want to have contact with him or do you want him to stay away from you?
Contact.
Are you in fear of him?
I'm not.
State, do you have any questions for Ms. Mohabir?
No, Your Honor.
All right. Does the defense?
No.
All right. State your position.
Your Honor, this is a first-degree felony punishable by life. Defendant is not entitled to a bond. However, based on the witness's position, Your Honor, I have no objection to you using your discretion to set a bond.
All right. Defense? All right, see, his risk assessment is low. I'll set a bond of $5,000 on count 1 and $100 on count 2. I'm going to order that you have no hostile contact with Ms. Mohabir. Understand that if you have hostile contact and it becomes an issue, law enforcement gets called, expect that the bond will get revoked. You'll probably be held on no bond. Okay, so you'll sit in jail. So no hostile contact. That means if you get into an argument, if you get upset, you just got to turn around and walk away. No more laying of hands. Okay, also order that you possess no weapons or firearms. All right. All right. Thank you, ma'am. Good luck. All right. Good morning, sir. Your name, please?
Good morning, Your Honor. Javon Henriquez.
All right, Mr. Henriquez, I think it was, we saw your mother earlier.
Yes.
Okay. You're here for initial appearance. You've been arrested for a battery.
Yes.
It's domestic related. State, you have a position on bond?
No position, Your Honor.
Okay. I will appoint the public defender. Defense?
For a reasonable bond, Your Honor. If I'm not mistaken, Your Honor, I believe the mother.
What's her name?
That's what I was trying to figure out. I believe you did a one-time return with both, so I don't.
Right, we didn't realize. I didn't
realize it either, Your Honor.
He was here.
That both.
Usually we would see them together so we would know whether they want to have contact.
And they both live together.
Yeah, I'm simply gonna, unless someone's got an objection, I was gonna set the bond at $500. I was gonna order no contact. I mean, clearly it's fairly, appears to be fairly volatile, so at this point I'd order no contact, and I'll appoint the public defender's office, and if they want to, someone wants to change that condition, they can certainly file a motion with the respective judge.
Well, I think the issue, Your Honor, is the housing situation. We told the mom she couldn't go back to the home.
Well, if that's where he's gonna live, if he's not living there, then, so it's,
So the mother, okay.
so I'm just gonna order, you maintain a separate residence, so I don't, maybe if she gets out of jail first and she's living there, then he's gotta live somewhere else, or if he's home first, then she's gotta live somewhere else, but I'm gonna order that they live separately. But as
Okay,
far
so
as,
you didn't do a no return on the mother, we just did a maintain separate residence?
yeah, it's
Okay.
to make, that's the court's intention is to order, you know, we run into this, not a lot, but it's not uncommon that, one person will move out or the other person will move out. And so I'm not ordering you not to live at any specific address. It's just, you just can't live in the same house with her. And she can't live at the same house with you. I've already ordered that.
Yes, Your Honor.
Okay.
Could he just, I guess, in case she gets out first, a one-time?
Otherwise, it'll be a one-time return with law enforcement to get your personal belongings if that's where she's living. Otherwise, no contact with her.
Thank you, Your Honor.
Good morning, ma'am. Your name, please?
Ajay Orr.
Ms. Orr, you're here for initial appearance. You've been arrested for battery. All right. At this time, do you want me to appoint the office of the public defender in this case, or you want to hire an attorney, ma'am?
Public defender.
Okay. All right. I'll appoint the public defender. State you have a position on bond.
No, Your Honor.
All right. Defense?
Just a reasonable bond, Your Honor. On a one-time return with law enforcement.
I'll set the bond at $500. I'm going to order that you have no contact with Mariah Nicole Pearson, that you maintain a separate residence from her. If she's residing at that Valencia Vista Way apartment, you're going to have to live somewhere else. You can return there one time with law enforcement to get your personal belongings. You're not to go back there alone. You're not to have contact with her. All right, good luck. Good morning. Your name, sir?
My name is Nicholson Powell.
Mr. Powell, you're here for initial appearance. You've been arrested for a violation of a pretrial release order of the court from earlier this week when I told you not to have any contact with the victim.
Yeah, excuse me, sir.
Do not.
I'm gonna appoint the office of the public defender. All right. And state, do you have a position on bond?
Your Honor, it'll be one of two things. Either you give him a bond on this one, but you revoke the PTR and either hold him no bond or then give him a bond, or I believe because he's violated, he's now not entitled to a bond on the violation of the PTR.
Defense?
I'd ask that you consider setting maybe a higher bond, and then should provision as opposed to holding.
Your Honor, he was calling from the jail.
Yeah, I read the affidavit. So, and it was numerous calls. All right. So on the new charge, the violation of the pretrial release condition, I'll set that bond at $1,000. On 23 MM 16112 AO, is that right?
It's too many numbers.
That's too many numbers.
I'm sorry, I mean, it's not here.
Yes, it's 1612. Yeah, 1612 AO. On that case, I'm gonna revoke the release and set bond at none. I've appointed you an attorney, and your attorney can file the motion in front of the judge. So your attorney can file a bond motion if you want to seek a bond back from the judge in in Division 50 downtown.
How do I do that?
I just gave you the number.
Call the attorney, ask the attorney to file a motion. Okay. Good luck, sir. Morning, sir. Your name, please?
Gary Smith,
Mr. Smith, you're here for initial appearance. Been arrested for a battery. It's domestic related. I'll appoint the public defender. State you have a position on bond.
No, Your Honor, he does appear to qualify for PTR. State has no objection.
All right, defense.
Your Honor, I would ask for pretrial release and a one-time return.
I'll release you on pretrial release with the following conditions: that you have absolutely no contact, direct or indirect, with Tina Labar, that you maintain a separate residence from her. If she's residing at that Selma Avenue address, you're gonna have to live somewhere else. You can return there one time with law enforcement to get your personal belongings. You're not to go back there alone. Otherwise, not to have any contact with her. Possess no weapons or firearms. Consume no alcohol or illegal drugs. All right, good luck.
Hello.
Good morning, ma'am. Your name, please?
Yes, sir. Good morning, Your Honor. My name is Jasmine Stevens.
Ms. Stevens, you're here for initial appearance. You were arrested for a battery. It's domestic related.
Yes, sir.
Okay, I'll appoint the public defender to represent you. State you have a position on bond.
No, Your Honor, she does qualify for pretrial release. State has no objection.
Defense?
I'd ask for pretrial release and a one-time return, Your Honor.
I will, I'll release you on pretrial release with the condition that you have no contact with your sister, Jawanda Stevens.
Okay.
That you maintain a separate residence from her.
I do. She would have to leave because me and my children do live.
Okay. Well, so we're on the same page.
Okay.
I'm ordering that you live separately from her.
Okay.
I'm not ordering where you live or where she lives.
Okay, thank you.
So I want to make sure that it's not misunderstood. If she resides and she's currently living at that 606 South Lakeland Avenue address, if that's where she lives, you're gonna have to live somewhere else,
Okay.
okay? Nothing to do with the kids. I'm not getting into that. So if that's where she lives, you have to live somewhere else.
Okay.
If she's living somewhere else, if she's moved out, then you can live there. That's fine.
Okay.
You just have to live separately from her. Otherwise, no contact with her, possess no weapons or firearms.
Yes, sir.
Okay, good luck.
Thank you, Your Honor.
Your Honor, where is mental health?
Defense will waive, Your Honor.
I'll appoint the public defender. And this looks like this is a warrant from the same day that he got arrested on the out on bond. The offense is the February 22nd. So I'll take no action on the out on bond. I'll stay the bond at $2,500. He's also got another battery. And state, do you have a position on bond on that case?
Your Honor, I have two batteries, but I do not, ooh.
So that, well, so on the, let me look at that. So we've got a warrant for a battery that occurred the same day that he was arrested, or excuse me, she was arrested on the felony out on bond.
Yes, Your Honor, and then there is also,
New battery.
yes. Your Honor, I would just like you to take into consideration the defendant has extensive history.
And Your Honor, on 1557, it looks like the warrant had it for bond and PTR. She would not qualify to be.
Yeah, I'll delete that condition of a pretrial release. Okay. Yeah, it appears it's a different victim.
Yes, Your Honor, I would ask that you take no action still on the out on bond and set a reasonable bond on the new battery. She has extensive mental health issues in a recent Baker Act. I just ask that you.
All right, so I'll stay the bond on the warrant, 23 MM 1557. I'll stay that $2,500 bond. I'll delete the pretrial release, order no return to the scene, no victim contact. In the new battery, 23 MM 1648, that battery, I'm going to order, I'll set the bond at $1,000, order no contact with the victim, Calvin Dwayne Thomas, no return to the scene, possess no weapons or firearms, and no action on the out on bond. All right. Good morning, sir. Your name, please?
Robert Brown.
Robert Brown. Okay. Mr. Brown, you're here for initial appearance. You've been arrested on a Seminole County warrant. Okay. Looks like 4 counts of burglary of a conveyance, burglary of a structure, possession of burglary tools. It's a total of 6 counts. And on the warrant, the bond is set at none, so they're going to contact Seminole County to come get you. They'll come get you within 24 hours, but that doesn't include the weekend, so it may be Monday before they get you. It may be today, I don't know. So, all right, but otherwise, Seminole will come get you. Okay, good luck. Morning, sir. Your name, please?
Adam Noor Hakim.
Mr. Hakim, you're here for initial appearance. You've been arrested on a Jacksonville Sheriff's Office, so I assume that's Duval County.
Yes, sir.
Okay, it's a Duval County warrant regarding charges of grand theft, criminal use of personal identification information. The judge put bonds, $50,003 on the first count and $25,003 on the second count. So if you're able to, you can post the $75,006 bond in Orange County and be released out of Orange County, and you'll be given court dates for Jacksonville. Or if you're not able to post bond, they'll contact Duval County. They'll come get you within 72 hours.
I'm gonna post bond. Try to do it today.
That's up to you. Okay? All right, good luck. Good morning. Your name, please?
Hello, my name is Isaiah Isaac.
All right, you're here for initial appearance. You've been arrested on a Seminole County warrant for failing to appear for a traffic, attaching tag not assigned, and looks like failure to have insurance. Okay, and bonds have been set at $263 each. So 263 times 2. If you're able to post bond, they'll release you here from Orange County, and you'll be given court dates in Seminole County. If you can't post bond, they'll contact Seminole County. They'll come get you within 24 hours, but that does not include the weekend. Okay?
Okay, am I able to speak?
Okay, understand that you got the right to remain silent about the facts and circumstances. I don't even know what they are. I just know what the charge is. I don't know anything else. If you have a question, if I can answer it, I'm happy to answer it.
Okay, so
Have one more. Thank you.
Okay, we're good? All right. Good luck.
Kevin Rivera bonded.
Thank you. All right. Good morning. Your name, please?
Robin Rivera Torado.
All right, ma'am, you're here for initial appearance. You were arrested on a, what do I have here? Fugitive from justice warrant out of Bedford County, Tennessee. Looks like for 4 counts of burglary, 4 counts of vandalism, 4 counts of theft of property. Bond is set at none. All right. So at this point, they're gonna, somebody will come see you from extradition. All right. And if they don't come see you, then you'll go see the after 30 days, you'll see the judge. It'll be another judge, it won't be me. Okay?
So the extradition process could take up to 30 days.
We dealt with this yesterday. It's, in a nutshell, they've got 30 days to get what's called, unless some people voluntarily signed and waived to go back. They don't want to just sit here.
Yeah.
I'm not saying one way or the other what you decide. You decide what you want to. If the person doesn't want to waive extradition, then the first, and someone correct me if they know what I'm saying is incorrect, initially it's 30 days. If the state needs, meaning the state of Florida, if they need additional time to get the governor's warrant, if they contact Tennessee and whatever, they can get an additional up to 60 days for a total of 90. But by 90 days, they've got to have you basically arrested or served with the governor's warrant from Tennessee. Okay? So, but somebody from extradition will come see you. Okay? All right, good luck. Good morning, sir. Your name, please? Mr. Bomar, you're here for initial appearance. You were arrested for a violation of probation. You were on probation for the offense of battery on a person 65 years of age or older. Allegations that you violated are you committed a new offense of battery here in Orange County. I'll appoint the public defender. The judge set the bond at none. Good luck.
Edmund Alton, refuse, Your Honor.
Defense will waive, Your Honor.
All right, I'll appoint the public defender. This is a on-view violation. Possession of MDMA and possession of cannabis. So on the on-view, I'm going to stay the bond at none. I'll take no action on the uncharged out on bond. And on the MDMA, I'll stay the bond at 1,000 and stay the bond on the cannabis at 250. I'll appoint the public defender in all cases. Morning, sir. Your name, please?
Madison Diaz.
Thank you, Mr. Diaz. You're here for initial appearance. You were arrested for a violation of probation.
Correct.
This is an on-view violation.
Yes, sir.
Okay. All right, looks like dealing in stolen property, grand theft. All right. And you were arrested for a new charge of possession of cocaine and possession of drug paraphernalia.
Correct.
I'm going to appoint the public defender in both cases. On the drug case, I'm going to stay the bonds at 1,000 on count 1, 500 on count 2. On the on-view violation, I'm going to stay that bond at none. Good luck.
Does that mean I can get bonded out today?
No, that means that you don't have a bond. You have a bond on one case. You have no bond on the other case.
Okay.
So there's no point in posting a bond. You won't get a release. So I've appointed you an attorney. If you want to have a bond hearing, that attorney
I
can.
actually have an attorney.
Okay. Well, okay, if you have an attorney, if you want to reset this initial appearance for that attorney to appear tomorrow,
yes,
we can reset it. You can seek to have the attorney appear.
Can we do that?
Okay, yeah.
Should I call my lawyer?
Well, otherwise they're not going to know. The court won't contact him. You'll have to contact him.
I'll have to contact.
So we'll set this for, we'll reset it for tomorrow. And what time would that be? About 11? 11 o'clock. 11 tomorrow morning.
11 tomorrow morning.
Yeah, so if you want to call your attorney and tell him to be in courtroom 1 at the jail, yeah, and the attorney, that'll give the attorney an opportunity to show up, and then.
Can I write this down real quick? There's a pen right here.
Well, hold on, let's make sure that.
Sorry.
Okay. We're in courtroom number 1, 11 a.m. tomorrow. That's the initial appearance, so.
And it's a,
Yeah, so I'll take no action on anything at this point. Just reset the initial appearance. Okay.
all right.
All right, good luck.
And is there anything else that I can
Give the
do?
deputy back the pen there. Okay.
I mean, is there anything I can do besides that to?
No.
No? Okay. Thank you.
Okay, good luck. Good morning, sir. Your name, please?
Ronald Lapointe.
Mr. Lapointe, you're here for initial appearance. You were arrested for a violation of probation. You were on probation for possession of cocaine. Allegations that you violated are that you failed to undergo a drug and alcohol evaluation, that you're in arrears on cost of supervision, that you're in arrears on court costs. All right, I'm going to appoint the public defender to represent you. The judge set the bond at none. All right, good luck.
Do I get a court date?
They are going to reset you. We don't have a court date at this point, but you will be reset for a violation of probation status hearing, or an arraignment in front of the judge. Okay. All right. Good luck. Good morning, sir. Your name, please?
Good morning, Your Honor. Dalkeith Morris.
Mr. Morris, you're here for initial appearance. You were arrested for a violation of probation. You were on probation for the offense of fleeing or attempting to elude law enforcement. Allegations that you violated are that you changed your residence without permission, whereabouts unknown, that you, let's see, there was.
Your Honor, we were evicted.
Don't.
Okay.
Don't.
Okay, that you failed to keep in touch and make a phone call to your probation officer when instructed, and that you're in arrears on your costs. The judge set the bond at none. I'll appoint the public defender to represent you. So if you want to have a bond, you can have the attorney file the appropriate motion in front of that judge. Good luck.
Yes, Your Honor.
Morning, sir. Your name, please?
Derek Walker.
Mr. Walker, you're here for initial appearance. You were arrested on view for violation of probation.
Huh?
Suspense violation of. And the all right, so look at something. Oh, isn't that on charge? Okay, so you were arrested on a new offense, possession of dimethyltolone with intent to sell or deliver. And it looks like you're on probation for grand theft and false verification of ownership to a pawnbroker. Okay, so I'm going to stay the bond at none on the on-view violation. I'll appoint the public defender. Morning, your name, sir?
Jeremiah Rojo.
Mr. Rojo, you're here for initial appearance. You were arrested for a violation of probation. You were on probation for the offense of assault. Allegations that you violated your probation are you committed new offenses in Volusia County, being those being fleeing or attempting to elude, operating a motor vehicle without a valid driver's license, and resisting an officer without violence back in January. The judge set the bond at none, and I'll appoint the public defender to represent you in this case. Good luck, sir. You'll be set for it. You'll be given a VOP. Actually, did we give him a VOP on its misdemeanor? Give him a VOP date?
I will enter a denial.
Okay, so we'll enter a denial, and we'll go ahead and set you for a violation of probation status date.
VOP status will be heard in Division 85, April 20th at 9 o'clock, courtroom 4A.
All right, good luck. Good morning. Your name, please? Spencer, you're here for initial appearance. You've been arrested for violation of probation. You were on probation for the offense of battery and assault, domestic related. Allegations that you violated are that you failed to keep appointments. Looks like 2 in January and 1 in February, current whereabouts unknown, in arrears on your cost of supervision, and that you failed to enroll in both the drug and alcohol evaluation and batter's intervention. The judge set a bond at $10,000, and I'll appoint the public defender to represent you. Okay, good luck.
Enter a denial or no?
I will enter denial, Your Honor.
So we'll give you.
Case will be heard in Division 50, VOP status, April 17th at 9 o'clock, courtroom 4E.
Get a big stack. Stay ready on the 33-day motions.
I am, Your Honor, but would you mind if we just did them second session?
That's fine.
Thank you.
That's fine. Yeah, no, we're going to break for 45 minutes.
I can talk. I don't want you.